waiting for more people to join. Look, now I'm very envious of you because you don't need to wear glasses. I noticed that both Diana and Chris are like me. Oh, you don't need them. Oh, lucky you. I'm afraid I do these days.
They're bifocal, so I can look at the screen without. When I look down, I need them.
Well, these days I need, they are reading glasses, but I need them even for the screen.
By the way, hello everyone.
Hello everyone. We're waiting a bit. We're still a little bit early, so we'll wait for more people to join. We have Antonella letting people in.
Hello, good afternoon.
Good afternoon. And if anybody has technical problems or the link is no good, you can ask Antonella. She can send you a new one.
Good afternoon.
Good afternoon. Right, Antonella, how are we doing?
At the moment we have 24 people, so
I think we should wait for a bit longer then.
a little bit, yes.
Yes, because we have 137 people registered, so it's better if we wait a bit longer.
Unfortunately, registration and participation are different things in these online days, aren't they?
Well, even in person is not always. But certainly there is more participation online than there is in person, particularly for us, because obviously being in Brussels, it's we have more limited so in many ways the online version of these events has the advantages, and I think we will probably continue, particularly for us in Brussels, because it allows for a much wider participation than in person.
That's absolutely right. Can you imagine if we'd actually tried to travel?
Well, at the moment, it's still very complicated. Particularly, I must say, between the UK and the EU is difficult. We are so used to just jump on a train and come to London or on a plane in Edinburgh. But now, I must say that the UK is very strict in terms of the the rules, all these things about having to have 3 tests is and a quarantine is expensive as well. Well, at the moment within the EU is easing very much. Between Belgium and Italy, for example, you don't even need a test. From the 1st of July, you don't need tests.
I didn't know that. It's interesting to know.
Yeah, because what they do, you have to fill a form.
Yeah.
And depending on what you say to them, they will let you know if you need to have a test when you get there or not. So they ask for vaccinations, they ask where you have been. So it's going to be easier.
You give me hopes, Rita, because I need to clarify for my mother, because we are traveling on the 5th of July to Italy, but she will be vaccinated completely, but it will be only 7 days between the second dose and the second shot and the 7 days.
This is the question of the 14 days, yes. The second. But still, it is much easier now. Right, I think we might even start with some introduction before we dive into the topic. Thank you very much for being here with us. Some housekeeping information. The meeting is recorded, so by joining, you are giving consent to this. There is as you all know these days, the chat facility in which you can put your question. So if you have a question during the speaker's intervention, you can write question in the chat, and then we will answer them during the Q&A. Of course, there is also the raised hand facility. So if you have a burning question or a question that comes out of another question, just raise your hand and I will give you the microphone. Please keep your microphone switched off because it makes for a much better reception for everybody. You can leave your camera on if you like, or you can keep them off. That is totally up to you. This webinar has been organized by the Brussels office of the UK Law Society. We have been in Brussels for over 30 years now, representative solicitor, and I'd like to stress that we are here to stay. We are committed to continue working with our colleagues from all over Europe and the EU institution to further and enhance the standing of our members and the profession. Please remember that we are here for you, and then you can contact us at any time if you want information, if you have questions to ask. You can visit our website. You can sign up for our monthly newsletter, the Brussels Agenda, which gives information on all the development of legislation in Europe. And of course, when you come to Brussels, just come and see us. Very happy to welcome you anytime. The exit of the UK from the EU has put a sudden focus on the question of dispute resolution. We have been lulled for years by the Brussels framework, problems of jurisdiction and enforcement of judgment, where the domain of practitioners at a wider international level. But suddenly we have been confronted with the loss of Brussels 2A, possibly the loss of Lugano. So the question comes, is litigation the only available means of dispute resolution, of resolving disputes, even at a wider, not national, but cross-border and international level? And that's why we are here today to explore answers. And we are going to talk about mediation with 3 expert practitioners. Before I introduce them, I would like to set the scene with a brief illustration of how ADR is considered within the trade and cooperation agreement. Don't worry, it won't be long. Because mediation, arbitration and conciliation are indeed mentioned in the TCA, but just all the agreement mention is the fact that lawyers acting for a party and therefore giving legal advice in a mediation, arbitration or conciliation are subject to the legal services chapter of the TCA. So therefore, if you are acting for a party in a mediation, arbitration or conciliation, and you need to know how this advice is going to be considered and how you can deliver it cross-border, you have to go to the legal service chapter of the TCA because you are considered as a legal services provider. But if you act as a mediator, arbitrator or conciliator, then you are considered as a professional services provider, and there is the relevant chapter in the agreement which deals with the service, with the providing of services. So you need to check under which category you fall. If you are self-employed, if you have a contract with a client in the UK or in the EU country, and so on. So you have to check that before you decide how you're going to be treated as a mediator or an arbitrator. With no further ado, I will now introduce our panelists, and remember to ask your question in the chat. Our first speaker is Lubna Shoya. She is Vice President of the Law Society of England and Wales, and therefore she'll be President next year, only the 7th woman to be a president of the Law Society since 1835, I believe. So that's an achievement. She is a solicitor, she's a mediator of great experience, and she works and has worked covering a variety of areas. And she will give us a broad view of what mediation is, how it compares to litigation, and will also touch on the question of the Lugano Convention. Our second speaker is Chris Newmark. He is a solicitor, a mediator, an arbitrator, and an academic, lecturing at the School of International Arbitration at Queen's Mary University, London. He was the chairman of the ICC Commission on Arbitration and ADR from 2014 and 2017, and he conducts his mediation through CIArb chambers. He will be talking about the role of commercial mediation in cross-border dispute resolution and how it compares with arbitration. Last but not least, we have Diana Wallace from the University of Hull. Diana is an old friend. She is a solicitor and a mediator, but she was an MEP member of the European Parliament for 13 years, and she was vice president of the European Parliament. And she was also the first president of the European Law Institute, and she was president for 10 years. She lectures on comparative law and European business law, and she will talk to us about the Singapore Convention. Lubna, to you.
Thank you very much, Rita. And can I say a good afternoon to everybody, and possibly good morning or good evening, depending on where people are joining from. Can I also add my thanks to everybody for attending today, and also to thank the other two members of our expert panel. Rita, the Law Society has been around since 1825. So it's about 10 years, 10 years longer. So we're almost 200 years old. And you're right, I will be the 7th female president and also the first Asian president. So that's good. We're making progress. Anyway, I'm here to represent the Law Society and to frame the discussion before Christopher and Diana get into the weeds of cross-border mediation. I am a mediator myself, but I am aware that we have got a mixed audience today. Some of you are mediators and some of you are not mediators. So I'm going to start the discussion with a consideration of why people might choose mediation, particularly over litigation, and how this trend could grow in UK and Europe. Now, everybody in this virtual meeting knows what mediation is, but it's important to consider it from the perspective of a layperson. So the client who does not deal with mediation day in and day out, what do they need to know? How do we persuade them to mediate and to be less litigious? We need to highlight the strengths of mediation in a way that is accessible and understandable for them. We can tell them that it's a very cost-effective way of solving a legal dispute, although this might be less important for those who are seeking to resolve a commercial issue for who costs may be less important. We can also tell clients that mediation is completely confidential and that any discussions won't be referred to in court should the mediation fail. We can tell clients that it's undertaken by an independent, neutral person whose only concern is to reach a mutually acceptable solution to a dispute. And we can also tell them that once an agreement is reached, it is legally binding on all the parties, so that court proceedings and the costs associated with those can be minimised. So who might we be trying to promote mediation to? Well, pretty much anyone. It can apply for private individuals, it can apply to companies, it can cover a complete range of disputes: matrimonial, contractual, property, negligence, employment, probate, commercial, construction, company, partnership, product liability, defamation, intellectual property, landlord and tenant disputes. I mean, the list goes on. It can pretty much cover any kind of dispute. But today we are focusing on commercial mediations. But I think the point that we'd like to make is that the more well-known mediation becomes in general, the more likely it will have a positive effect across all areas of dispute, and the more likely it will be used. I firmly believe that a properly conducted mediation will always be a valuable investment in, perhaps if somebody could mute.
Yes. Could you please mute yourself? Thanks.
Thank you. Yes, I was saying a properly conducted mediation will always be valuable investment in time, effort and resources for a client. Sometimes it's the first time that clients will meet face to face since their dispute has arisen, and it's also likely to be the first time that lawyers from both parties come together. So that alone can provide an opportunity to move the case forward in a constructive way, allowing each party to assess and analyse the merits and weaknesses of their respective positions. We all know, or those of us who are mediators on the call will know from experience, that during the course of a mediation, some new information that will impact on the eventual outcome nearly always comes to light, whether that's new facts, new evidence, some insight into why the other party is so committed to their position, or an awareness of something that the client might not have even disclosed to their own lawyer. Rita, I can see somebody's screen sharing.
Yeah, exactly. Somebody is sharing their screen. Andrew Parsons? Could you please stop sharing your screen?
Sorry, I didn't mean to do that. Sorry.
So to continue, so the new information that may come to light, it can't be used outside the process, but it will often affect a client's position, any offer that's made, and the conduct of any future litigation. Even if a mediation is unsuccessful, we know that many disputes will settle very shortly after the mediation takes place. I can see, Rita, that they are still screen sharing. I'm just mindful that there may be confidential information they don't want to share.
You're still sharing your screen. Could you please try to unshare it? Thank you.
That's better. So turning to mediation as opposed to litigation, the majority of the public see settling a dispute as involving courtrooms, briefcases, wigs and gowns, lots of drama, and their point of view being completely vindicated by a very sharp, forthright, and ultimately fair judge. Now, it's fair to say that litigation is much closer to that imagined scenario than mediation. So that does put mediation as a little bit of a disadvantage, because some people are suspicious of the less dramatic, more cost-effective option, which regularly features in TV dramas. But we need to explain to clients, how do litigation and mediation compare? And I would say that there are three main differences. The first difference is in relation to control. Litigation can have a momentum of its own, which comes hand in hand with escalating costs. On the other hand, mediation involves the parties having a much greater degree of control. They've agreed to participate and they can leave the process at any time that they want to. Litigation carries major risks: time, cost, the likelihood and the value of an award being completely unknown to the parties. Mediation, on the other hand, is more predictable in terms of cost and time, and the parties do have some say in the final outcome. The second difference is the framing of proceedings. Litigation tends to be adversarial, whereas mediation is much more cooperative. Parties in the mediation are, we would hope, attending the mediation with an intention of finding an equitable settlement, compared to the win or lose mindset, which many clients are encouraged into in a litigation process. The third difference is the results. Mediation is capable of achieving solutions that are fully beyond any remedy a court might award, whereas the judgment is much more limited in imagination. So it's useful to remember that the rate of successful mediations, i.e. those that settle, sits at around 80%. And often they can come up with a resolution and a settlement which cannot be awarded by the court at all. So in my mind, those are the key comparators, and they're useful to inform clients when you're talking about what their options are and trying to discuss with them whether a mediation might be appropriate for them. Mediation has been growing in popularity and prominence, particularly in commercial disputes. As you would expect, there has been a growth in Brexit and pandemic-related disputes, particularly involving insolvency and restructuring. But that may not be the only impact that the coronavirus has had. We've become much more used to remote proceedings over the last year, and it seems that they are in a large part here to stay. According to the Centre for Effective Dispute Resolution, mediators and lawyers agree that there is likely to be an increase in the overall level of mediation activity because of online mediation. It has been very successful, partly due to the attraction of the decrease in costs and the decrease in the time required for mediation. That has increased accessibility and appeal for the process. Coupled with the already established advantages of mediation over litigation, it presents a perfect setting for cross-border mediation to grow. Companies are still feeling the effects of two seismic effects that have happened in quick succession. And right now, the advantages of quick, cost-effective dispute resolution during which control is maintained has never been more appealing. So moving on to the Lugano Convention, one question that has a great deal of relevance to the future of mediation is whether the UK will be able to access the Lugano Convention. While legal services are rightly recognised within their own chapter in the EU Trade and Cooperation Agreement, which came into force on the 1st of January 2021, there were no measures on enforcement of judgments and judicial cooperation. The UK applied to access the Lugano Convention in its own right in April 2020. And that is something that the Law Society has long campaigned for. There may be some of you actually asking, what is the Lugano Convention? Well, Lugano supports the autonomy of parties to a contract to be able to choose a jurisdiction in Europe where they wish to settle their dispute. It also allows the continuation of the current choice of court agreements despite Brexit. When we left the EU and the transition period ended, we exited the common framework for jurisdiction, rules, and enforcement of judgments. Lugano supports access to justice for the parties, offering certainty about the jurisdiction where a claim can be brought and allowing judgments to be recognised and enforced with a minimum of fuss and cost. It also allows the parties' right to choose their own court to be respected in all circumstances. It provides protection where one party is deemed to be weaker than the other. So, for example, in employment cases, insurance or consumer contracts. Litigation becomes more accessible in those sorts of areas. Without Lugano, litigation will be pushed beyond the reach of all but those with the deepest pockets, and will inevitably limit access to justice. It means reverting to the national laws of each individual country to decide which court has jurisdiction over a legal issue and whether a judgment will be recognised and enforced. The decision lies with the European Council, who will vote on a proposal from the European Commission. In early May, the Commission recommended the EU block the UK from joining Lugano on the basis that the UK is not a member of the European Economic Area or the European Free Trade Association. It appears that no proposal has been made to the European Council for a formal decision to be made at the moment. However, the non-EU European Free Trade Association states have already said that they are willing to support the UK's application. This raises serious questions for businesses, consumers and families both in the UK and in Europe. The Law Society continues to make the case for UK accession to EU stakeholders through our Brussels office and to the UK government so that they can prioritise securing accession through diplomacy. We've organised joint letters from consumer and trade bodies to EU decision makers and conducted information campaigns. But what does this mean for all those who have disputes across borders at the moment? We are already seeing the effects of not having access to Lugano. Commercial parties transacting across borders are trying to reduce uncertainty in a couple of ways. They are amending or including dispute resolution clauses in commercial contracts, and they are adding in exclusive jurisdiction clauses, thereby subjecting the agreement to the 2005 Hague Convention, which the UK and the EU are both party to. More importantly, and of relevance to today's talk, they are also turning to mediation to resolve disputes. As stated earlier, mediation offers options which may not be achievable through pursuing litigation, and it removes some of the uncertainty connected with the loss of Lugano. Even if the UK secures accession to the Lugano Convention, as we at the Law Society are trying to achieve, those with positive experiences of the mediation process are more likely to use it in the future. I hope that's provided some useful context for more specific points that will be covered by my esteemed colleagues on the panel, and I will now pass back over to Rita. Thank you.
Thank you very much, Lubna. I must say that you are very convincing. Now, if I ever have a dispute, I'm going for mediation. Definitely. Even if as an Italian, we tend to be quite litigious. Chris, over to you.
Yeah, thank you very much, Rita and Lubna, and good afternoon, everybody from South London in my case. I'm just interested, actually, Lubna, in that last point you made about Lugano and parties, the effect on it of parties putting in clauses providing for mediation, and I wonder whether you might also see an increased use of arbitration clauses in commercial contracts, but that's just an observation before I start. What I'm going to be talking about mainly is mediation and arbitration, and how they're being used for cross-border commercial disputes, how comfortable they are sitting together at the moment. Are they working in a complementary way, as they certainly should be, to facilitate efficient resolution of cross-border disputes. Lubna's talked a bit about the differences between mediation and litigation. Let me just emphasize some of the points, and slightly different ones, about mediation and arbitration. As many of you will know, arbitration, like litigation, leads to a binding decision delivered by the arbitrators in an award. It's based on fact and on law, and unlike litigation, there are very limited rights of appeal. Because of the emphasis on fact and law, it requires the submission of legal argument and of evidence, and because of that, it has somewhat similar expense, cost, and often similar duration as litigation. Of course, that varies from case to case, and countries differ as well. Mediation, however, is a very different beast, and again, Lubna has described this and some of its features. It's a commercial negotiation, not a decision, not an adjudicative process. It's a negotiation facilitated by a neutral mediator, and it can lead to a settlement agreement. And as Lubna said, that can be binding, and it need not be confined to the sorts of outcomes that a court or arbitral tribunal would rule upon. It could be a new contract, for example. And of course, if the parties aren't able to reach agreement, don't find the agreement on offer better than proceeding with arbitration or litigation, then they can walk away and continue with arbitration or litigation. Importantly, it's much quicker and much cheaper than arbitration or indeed litigation. Often the mediation itself taking place over a single day, with perhaps just a couple of weeks or more, or a little more of preparation. Now, arbitration is a very popular tool for resolving cross-border commercial disputes, and that's cross-border internationally, globally, not just within an EU context. I would say it's globally, it's arguably the default dispute resolution process for international business. But in contrast, mediation is still not widely used. Its use is certainly growing, but progress is pretty slow. So why that marked difference? And also not just a difference in the use of mediation with arbitration internationally, but why such a marked difference between we've seen the growth of mediation in the UK, where commercial mediation really is very much part of the mainstream now. Why has it not become part of the mainstream yet in international disputes? Well, arbitration, of course, has a very long and successful history, and importantly, it's a history which is embedded in both the civil and common law traditions and countries, and I think that is important. And it's met the needs of international business as an alternative to state litigation for many, many years. It offers global enforcement of those binding decisions under the New York Convention. It offers neutral arbitrators and neutral venues as opposed to state judges and venues in a particular jurisdiction. It offers confidentiality rather than the typically public court proceedings. And again, rather attractively, and something that I'm going to come back to a little bit, attractively for lawyers, it pays well. It pays well for law firms, it pays well for advocates, it pays well for arbitrators and for arbitral institutions. And unfortunately, I do feel that this financial element in terms of the remuneration of those involved in the process is somewhat key. Mediation, in contrast, is new. It doesn't have that deep history that arbitration has. It's something that lawyers, many lawyers in many jurisdictions, think they can do for themselves. They think they can settle cases themselves and they don't need the involvement, and they are rather reluctant to agree on the involvement of a third party to help with settlement. For many, mediation is viewed as an American or a common law technique, which is really only required to avoid the excesses of litigation in those jurisdictions like the US or the UK, but not needed in countries with faster or cheaper court processes, typically the civil law countries. That's a common perception, I think, viewing mediation much more narrowly in terms of its advantages than is actually the case, as Lugano has already mentioned. And importantly, mediation will be viewed as a threat to lawyers and to arbitrators and to arbitral institutions. None of those participants make nearly as much money out of mediation as they do out of arbitration. If you think about an arbitrator who generally loves getting a new case and loves seeing it through to an award, maybe paid by the hour, but certainly will be paid most upon delivery of an arbitral award, you compare that to a judge who loves cases to settle because the judge gets to clear his or her desk and is paid the same irrespective of whether their case is settled or they go to trial. And then lawyers from different jurisdictions, EU and elsewhere, currently have very different experience and expectations of mediation. I've done some teaching of mediation in Germany, and I've done it in the UK and in other countries, and the type of mediation that people are expecting or are familiar with varies quite significantly. And that makes it much harder for lawyers to quickly agree on using mediation or agree on the choice of a particular mediator and to propose the process to their clients and get their clients on board. That's much harder in a cross-border context where law firms come from different jurisdictions as their clients do, because they're not necessarily speaking the same mediation language. To give you an example, in Germany, it's very, and this will apply to other civil law countries, it's very typical for, even in commercial mediation, for the plenary session with everybody together to be the primary tool that's used with much less use and sometimes extremely limited use of private meetings, confidential meetings between the mediator and the individual parties. But people familiar with mediation in the UK and the US and elsewhere will know that private caucus meetings are very much the bread and butter tool of mediators. So those differences make it much harder, as I say, in cross-border disputes for there to be that quick and easy agreement on mediation as a process to be used. So those are some of the differences and with them the obstacles to the growth of mediation alongside arbitration, and why those who are willing to recommend to their clients and the clients who are willing to go to arbitration may have some hesitancy about mediation. But there are a number of positives, and I have to say, I think speed is picking up, momentum is increasing in this respect. For some years, we've seen we've seen tiered clauses being used. These are the dispute resolution clauses in contracts, which typically provide for negotiation first, and if negotiation doesn't succeed after a certain period of time, then mediation, and only after mediation has not produced a binding agreement, only then can parties resort either to arbitration or to litigation. I don't necessarily think those clauses are ideal. Probably not time to go into the explanation of that right now, but I do think they have definitely helped to assist in the exposure of lawyers and parties to mediation, because it's been a step which many have gone through, which they wouldn't otherwise have gone through if that clause hadn't been in the contract mandating the use of mediation before arbitration or litigation. We are now seeing the promotion of mediation by arbitral institutions. It's not always wholehearted, because, as I said, most of the arbitrations prefer the bread and butter work of arbitration, but many, perhaps even most institutions now have their own mediation rules. As I say, not all of them promote those mediation rules as actively as they promote their arbitration rules, but they're there and are being used to some extent. And some institutions, and I'd list the ICC, which Rita mentioned in my introduction, I have a close relationship with, or have had, working with the Commission over a number of years. Some institutions are encouraging the use of mediation both either before or during arbitration, and making it easy for parties to switch between arbitration and mediation in the course of proceedings, making it efficient to do that and cost effective to do that. I think arbitrators are increasingly recognizing that promoting settlement is part of their role. They're not just there to decide the case. They're certainly there to at least create the right room and space for parties to settle. Rarely to actually get involved in mediating themselves, getting involved in med-arb, that's unusual and rare, but there is an increased willingness of arbitrators to suggest, for example, mediation windows in the process, so as to enable mediation to take place in the course of arbitration. A little over 10 years ago now, I was involved in setting up the CEDA Settlement Commission on Arbitration. It was a commission which was tasked at looking at ways of increasing the settlement rates of cases in arbitration, because it was recognized that for some reason, whereas most cases that go to litigation settle before trial, a far fewer percentage of cases that go to arbitration settled before a final award. That commission was co-chaired by Lord Wolfe and Professor Gabrielle Kaufman-Kohler, so highly renowned jurists from the litigation and arbitration backgrounds. It produced a report which was well received, but unfortunately it was before its time 10 years ago. But it's coming back now and being talked about, and to some extent being relaunched, and there's much more interest as we learn from jurisdictions like Germany, Switzerland, China about the way that arbitrators proactively encourage settlement. There is much more interest in this now. So I am very much encouraged by that. So as far as the future is concerned, mediation and arbitration certainly should become fully complementary and be used in combination. Too often we hear about either or in terms of these processes, and it's not an either or choice. It's a question of using the two together and at the right time. Mediation can be used with arbitration, not instead of arbitration. I think there is a need for a resolution to the financial incentives for arbitrators to assist parties to go off and mediate, even though that may mean the arbitrators don't see the case again because it's settled. So perhaps greater consideration about fees for arbitrators, which include some incentive for case settlement. Difficult area and controversial probably, but it might help remove one of the obstacles. And there's lots of good training going on of lawyers in all jurisdictions about mediation, and that training is going on within the arbitration community, and it's good. And what it does do is help us move towards a more broadly accepted sort of international model for mediation. Arbitration over the years has developed its sort of homogenized version of itself via the IBA, various IBA rules, whereby the civil law and common law traditions have become combined in something that people recognize as international arbitration. We need to carry on the initiatives to do that with international mediation, so that whichever jurisdiction you're from, as a lawyer, you feel comfortable and confident in recommending mediation to your clients, knowing what it is that they're going to get. Thanks very much, Rita. Thank you, everybody. I'll be pleased to deal with any questions or follow up later.
You're muted, Rita. Rita, we can't hear you. You're mute.
Sorry, I mute myself to avoid and then I forget. No, I was saying that. Thank you very much, Chris, and certainly very stimulating. I have got quite a few questions of my own on this, but before that, Diana and the Singapore Convention.
Thank you, thank you, Rita, and thank you for the Brussels office of the Law Society for arranging today's event. That's, I think, hugely appreciated for solicitors to put a focus on mediation. That's really good, and also, of course, the cross-border aspects. I just wanted to pick up one of the last points that Chris made, which I think is important for the future. I mean, I'm currently engaged in teaching at the University of Hull, and there are now many universities around the UK who offer a standard part of their undergraduate course in law, mediation and ADR. So I think we're going to see a generation of younger lawyers coming through who have both much more knowledge and much more inclination towards ADR in general and mediation in particular. So I think that is a positive point for the future. For today, I've been asked to speak about the Singapore Convention, which I think is one of those other elements that now has the potential, and I say potential, to make mediation a more attractive prospect in a cross-border context. And that's in two scenarios. Within the Brexit scenario, where we've lost the mediation directive, which, let's remember, was specifically targeted at cross-border. It was cross-border in scope. So we've lost the comfort there, which gave us some ability or some certainty around enforcement of mediation settlements within a European context. And now we're sort of completely at sea. We don't know whether judgments will have enforcement under Lugano. We're not absolutely clear what's happening with mediated settlements in Europe. And the whole thing looks a bit uncertain. But into that uncertainty has come this new instrument called the UN Convention on Mediated Settlements. And if we're honest, it was really, I think, an attempt over many years by many people in the mediation community who thought and have hoped that if mediation had an instrument like arbitration has the New York Convention, then, hey, mediation would suddenly be as attractive and as well used as arbitration. I'm not 100% convinced that that argument follows, but I do think in the current context that we face in the UK, it does certainly make mediation much more interesting in an international context, because you've got this possibility of enforcement, which should make it more attractive. I'll come back to whether that should really be the case in mediation later, but let's take a bit of a look at the convention and why it's potentially, I think, exciting. It's exciting because it's attracted a lot of interest. The final text was adopted in 2018, and it was signed by a pretty convincing set of 46 countries in 2019. It quickly got enough to be ratified in September 2020. But of course, the ratifications are still not as good as the signatories. The signatories include the likes of China, US, India, Turkey, and of course our own country. Now, if that's the case, without Brussels and or Lugano, if worst comes to the worst, something like the Singapore Convention alongside of the New York Convention begins to look like an attractive option, and all the more reason, on top of the reasons we've already heard this afternoon, for using mediation and putting mediation into one of those tiered clauses in a commercial contract. So it's there, what's, as it were, in the box of the Singapore Convention. What do you have to enforce a mediated settlement under this convention? Well, in a sense, it's quite light touch. You've got to have a mediated settlement, it's got to be international, and it's got to be commercial. So that's what we're talking about today. This is nothing to do with consumer cases, nothing to do with family cases. This is pure and simply commercial cases in an international setting. In terms of how do you define what is a mediated settlement, again, the convention is quite open in a way, a very simple definition of mediation that we've seen elsewhere, for instance, in the EU directive. Something is a mediation irrespective of how you describe it or the process is designated, if what you've got are parties trying together to reach a settlement with the help of a third person or persons. The important bit, I think, or the sort of differentiating bit in the Singapore Convention is that it states that that person must lack the authority to impose a solution. Now, those of us who sort of mediate would see that as taken for granted, but it makes that clear distinction between mediation and arbitration, and also any sort of strange ideas about mediation that some might see that lead more towards a model that tries to impose a solution. So it mustn't impose a solution. The agreement, obviously the mediated agreement that you want to enforce internationally has to be signed, as you would expect, by the parties. It could also be signed by the mediator, and I would say it always should be. It could also be signed by the equivalent of a mediation institution or panel. So the basic elements of what the convention defines as a mediated settlement are really quite simple. I think those of us that were skeptical about this convention were skeptical because we thought that if you allow a foreign court to enforce a mediation settlement, it's going to give that court the chance to open it up and look within it at the mediation process, which could endanger some of the things that mediators feel very strongly about in mediation, the voluntariness of the process, the confidentiality of the process, and all sorts of other things. But in fact, I think, again, the convention is quite well done in the sense that the only reasons for refusal of enforcement that allow that sort of potential, and I say potential, opening up and judicial interference with the mediation process are if you've got a mediator who has really been guilty of some form of misconduct, or a mediator who has failed to disclose a conflict of interest. And as a result of either of these things, you've got parties entering into a mediation agreement that they wouldn't otherwise have thought to enter into. So it's quite, those are quite serious events in terms of what you would have to show to open up a mediation agreement in an enforcing court. And therefore, hopefully, this won't mean an overbearing judicial interference in mediation, which I think some of us were perhaps concerned about. I think the other big plus point of the Singapore Convention, particularly if you compare it with New York, is that with this convention, the mediation settlement is, in a sense, almost stateless, and the only requirement to enforce is that it is the enforcing country that has ratified. So it doesn't matter where the mediation was carried out, or if it was carried out online, or who the parties were, etc., etc. You've only got to look at what is the position in the country where you want to enforce. Has that country ratified? So that, I think, is also a plus, whereas in New York, with the New York Convention, you require this element of reciprocity. So on the face of it, it looks good. Obviously there's not enough experience out there of the convention yet to know how it will function, how it will fare, and we need a lot more ratifications, particularly the UK. And I know when we've had the chance with the EU Committee of the Law Society, we've made that point to various civil servants from the Ministry of Justice. So it needs, I think, a concerted lobbying to make sure that the UK does ratify and indeed encourages others to ratify. Because I think the other big point going down the track, if you look at some of the speeches made by our new Master of the Rolls, Sir Geoffrey Voss, who I've worked with on ADR matters, there is no doubt that he wants to place ADR at the centre of the civil justice system, and that means mediation. And if that's the case, I mean, inevitably, some things about mediation and how maybe, dare I say, it's regulated will possibly in future change. But it does mean there's going to be much more mediation. If we've got somebody sitting there as Master of the Rolls doing this advocacy for ADR and mediation, then that's a plus point. And if it's happening domestically, let's hope it will also likewise encourage more take up internationally, and perhaps the Singapore Convention, despite the doubts that some of us have, may be a big part of that. Thank you.
Very much, Diana. Fascinating stuff. I have some questions. I have a question actually straight to Diana about the Singapore Convention. And the question is, why doesn't the Singapore Convention include family law? And would a family law mediation convention for international cases be a good idea?
I think it was felt that it was commercial, and that was if you go into family, it becomes family mediation, as we know, even here in the UK, is seen almost as a specific sector with a different route of qualification. And family law in general in cross-border issues tends to take different routes. Of course, there are international conventions to do with family matters through The Hague, but I think it was probably a wise choice not to involve family, and to keep it as commercial.
Thanks. I have a question for Chris. In respect of the CIArb rules for the facilitation of settlement, the question is, I'm wondering whether there's been any assessment of the uptake and impact of the CIArb rules since their introduction.
The simple answer is no, there hasn't. No formal assessment. I'm not quite sure that it would be possible to do that anyway, given that so much arbitration takes place confidentially, and it would be difficult to actually find out whether there has been any reference to the CIArb rules. I have to say, I have not seen it in the tribunals that I've sat on, notwithstanding my own interest in these rules, and talking to others who are very keen on and enthusiastic about this area, that they haven't either. So I mean, I think it's generally accepted that the uptake and impact has been low and the impact has been small. But we are right now actually looking at trying to change that, because having a group of us having looked at the rules again, actually think they're just as applicable today as they were when they were launched 2009, and they're worth some sort of further promotion in the hope that they might become a bit like the IBA rules on the taking of evidence in commercial arbitration and the other IBA rules, where they are something which parties, counsel and arbitrators can have access to. They don't need to incorporate them fully, but they can resort to them and use the principles as they see fit in their cases.
I have a question for everybody, which is more a political question than a technical one, which is referring to Lugna's intervention, and it's Andrew Parsons, and says Lugna makes a good point. Reciprocal enforcement of judgments works both ways. Surely the politician in the EU won't be stupid and block the UK from Lugano. I don't know if you have any comments on that. I'd have many comments. Would anybody would like, maybe Diana or Lugna?
Okay, I'll make a comment. I'll say first of all, and you're going to hate me for this, but if I was still sitting in Brussels as a politician, I probably would be very cautious of admitting the UK to Lugano. It is bound up with Europe's internal market, and of course it does also give a nod to the decisions of the European Court of Justice, which we have decided we want nothing to do with. So it's difficult. Sitting this side of the table, my view has always been that the Brussels Convention and Brussels Regulation and Lugano are access to justice instruments. And as you rightly say, access to justice works both ways. And what I don't want to see is many consumers, many small businesses, others unduly suffer not being able to enforce their rights. So I do think on all fronts we ought to be, as Lugna said, emphasising absolutely these access to justice points, and that's the important thing going forward. And I think there are now increasingly a number of targets in Brussels who are beginning to get it, and we've also been aided by some recent lobbying on those who are interested in business and human rights cases, which would also be detrimentally affected. So I think that the thing is being propelled in the right direction, but it needs politicians on both sides to really work hard at this. My fear is Mr. Frost. I'm not sure he's keen, however much we lobby.
Dana, can I say thank you for that carefully nuanced and humorous answer.
I think also, Rita, Tim O'Sullivan has very kindly posted a reply. He's a member of our Law Society EU committee, and he's very kindly posted a response in the chat as well. And I would absolutely defer to the expertise of our EU committee. As you said, I think this is very much a political decision, and it is about, you know what, if you want to go, you're not going to get the benefits, off you go, because they're protecting who's already within Europe, and they don't want other people to say, well, if they can do that, why can't we? So I think it's a whole it's a whole big can of worms, isn't it?
I must say that one of the things that I have been thinking is now that Switzerland has, and the negotiation between Switzerland and the UK have sort of broken up. If Switzerland leaves the European Economic Area, now, isn't Switzerland going to be member of Lugano anymore? That's no. So if they can stay, why can't we? So there is certainly that question.
We're being
Right.
punished,
Another
Rita.
question. Yes, Diana.
There is a reason, Rita, because the Swiss judges discreetly give a nod towards the European Court of Justice. And that's what we won't do. That's the problem.
I have another question from Daniel Erskine. I have seen more business clients foregoing mediation or arbitration or multi-tier contract clauses in favor of court resolution because the uptick in courts insisting or referring disputants to ADR within the court process. Any thoughts on how to convince them otherwise? I think, I'm not sure, but this is quite linked. Yes, this is one for Chris, linked to a question that I meant to ask, which relating to compulsory ADR. So, Chris.
Well, I sort of had a question back for Daniel as to why he feels that you would want to convince people otherwise. What is wrong with a preference for a multi-tier clause, first of all, and secondly, what is wrong with courts referring disputants to ADR?
Nothing primarily, but as we all know, it causes a lot more cost. You know, particularly in cross-border, we're not only seeing local counsel, but local counsel on top of local counsel to advise. And oftentimes, for example, we just did a thing for the UAE that would very much have lent itself towards mediation, arbitration, and the client insisted on reference to the courts there. And so I think there's a cost savings to the client, but I think there's also. Go ahead.
Sorry, I misread. I misheard. Okay, I thought it's more businesses going for multi-tier. It's foregoing multi-tier clauses. Okay.
Right.
I'm sorry. I got you around the wrong way. My apologies. So how do you encourage parties to go? Okay. Sorry.
We want to use your services and whatnot. That's why I'm trying to give you guys more work.
So you're saying clients want to go to court because the court will insist on ADR? Correct.
They just feel more comfortable. They feel that there's more predictability in the process, particularly when in disputes regarding UK parties and US parties, for instance, to go to the UK courts or to go to the New York courts. You know, and like I said, an example, just did a deal in the UAE where they insisted that we go to one of the offshore courts rather than any arbitral or mediation beforehand. Yeah.
Well, it may come as a surprise to you, but even though I make my living by being an arbitrator and a mediator, I still am of the view that if there isn't a good reason not to go to the English courts, if you're looking at the English courts as then you should go to the English courts, because you don't have to pay for the judges, or much less than you pay for arbitrators. You get very high quality justice. You get appropriate access to ADR, as you've mentioned. And you should really only go to arbitration if there is one of the compelling reasons to do so, like you need the New York Convention for enforcement, or you need confidentiality, or one of those things. So although I'm an arbitrator by practice, I would still encourage people to use the courts where the English courts can do the job. So I'm afraid I don't, even though I heard your question around the wrong way, I still wouldn't necessarily be in favour of the multi-tier clauses if parties can get what they need out of the English courts.
Thanks, appreciate it.
This is interesting. So since I'm here and I have chair privilege, I would like to play devil's advocate for a moment. And there has been you have all talked about how good mediation can be. And also, Chris, you were talking about the fact that in the UK and in the US, the mediation process, an important part of mediation process is the private meetings between the parties and the mediator. And I just think, again, as a litigious Italian, I'd be a bit suspicious if the mediator is meeting with the other party. What are they talking about? What are they saying to each other? Are they going to sort of try and pull a trick on me? And I think this is very much the attitude of continental to this. What do you think could be put in place to increase the confidence of people doing mediation, going for mediation, rather than going to court, particularly in these countries where there is this attitude and this form of suspicion?
Well, it's interesting coming from an Italian lawyer that you say that, because I understand you've had, to some extent, compulsory mediation in your country. In certain contexts.
But it's on
perhaps that hasn't
family.
worked.
But that's why it is compulsory, because otherwise nobody would do it.
Yeah. I mean, on the particular point you mentioned, I think it's largely training and experience, and then experience can come through role plays in a training context. Because when people in a role play, and when we train mediators at CIDA, we role play, and people who haven't necessarily been through the process before, and then see how the confidential private meeting sessions work, and feel the benefit to them when they're playing the role of a client and they get to talk to the mediator in private and tell the mediator exactly how they feel about the case, and get things off their chest and stress what's important to them commercially and stress what's important to them, even though they know that none of that is going to be told to the other party, even they know that the same discussions are going on in the other room. They feel the benefit of that, and they also feel the benefit of the mediator coming back into the room and saying, just taking into account what's important to you, taking into account what is important to the other side, which I've learned about. I think this will be a constructive way forward. And they think, oh, well, okay, that's great. That's something we hadn't thought of, or we're very glad that you can now direct us in this positive direction. So I mean, you don't have to go through mediation itself to sort of get a hold of that and start to grasp the issues. And the other thing I would just link to that is saying, you said, play with the fear that the mediator is going to play a trick, or the mediator is going to, what are they up to in the other room? The bottom line is it's no risk in mediation because the mediator has no power to enforce anything, and a party retains both parties, all parties retain ultimate control. If they don't like anything, they walk away. So even if there are going to be things going on that in private, which you feel uncomfortable because you haven't got full visibility, at the end of the day, if you don't like the end product, you walk away with only your time and money in the mediation process spent, and no other damage done.
Thanks. That's.
I think Rita, just coming in on that as well. I think part of the trust building is also pre-mediation. So it's the kind of the dialogue that you're having with each of the parties before the mediation actually starts. And part of that is building trust with them understanding that you're treating both parties very equally. Whenever I have communications with them, I will say I have written in similar terms too. I am asking them for the same information. I am not going to share what you're telling me, and nor will I share what they're telling me either. So I think part of that trust building is actually before you get into the going off in private rooms talking to the parties, because you build the trust with them so that they trust you to do the right thing for both of them.
Another question from Jonathan Lutz. Should mediation be made mandatory? That's for you. What do you think?
Yes. Yes.
Okay, that's a clear answer. Yes. What
So we can't let that pass with a one-word answer. Come on, we got to do more than that with. I think so just in the arbitration context, arbitrators I don't think can force parties to go off and mediate, but I am interested in the arbitration context of possible, and this would have to be done by agreement between the parties in advance by reference to the arbitral rules or a procedural order. For example, giving the arbitral tribunals the sorts of costs sanction powers that the courts currently have. So, post award, if one party comes forward and says, "Look, we've done better than we offered, or we offered to mediate, and the other party refused, and this thing could have been settled ages ago, and we'd have saved hundreds of thousands of euros or dollars or whatever it is," then giving arbitrators the power to sanctioning costs like the English courts have, I think that's interesting. But we're in that context, we're a long way away from making mediation mandatory. I'm not in favour of making mediation mandatory. I'm quite removed from the English court process, but I feel the English court has settled on a good balance of incentives to mediate, disincentives not to mediate. And I think certainly I see in commercial cases, most commercial cases having a go at mediation at some point before they, and sometimes many points before they get to trial. So I don't think we need mandating. I don't know why Jonathan asked the question. I'll be interested to hear from Jonathan.
Okay, Rita, may I make a brief?
Yes, of course.
Firstly, there are two articles I'm aware of which suggest that arbitrators do have the power to stay the arbitration, give a window of opportunity for mediation to take place. They can't compel it, but they can allow that window of opportunity, and then have the power to make an adverse costs order, just as the court could do if a party refuses. One of those articles was written by Lord Wolfe in an address he made to the Chartered Institute many years back. The second article was written by me, again, quite some years back. You may agree or disagree. My proposition is based largely on Section 33 of the English Arbitration Act 1996, which says that the arbitrators have to act in a manner so as to avoid unnecessary delay and expense. Firstly, their task is not necessarily to proceed to an award, but to assist in securing a resolution and a resolution without unnecessary delay or expense. So I say that they have the power pursuant to that to direct a mediation window. Yeah, there it is.
Have you tried it, Jonathan?
I have viewed favorably. I also sit as arbitrator as well as mediator. I have received submissions that there should be such a stay, which I viewed favorably. Whether I've always been able to persuade my co-arbitrators is another matter.
Yes, I can imagine that would have been a hurdle.
Yeah, not always.
Right, we have another question from Rebecca Atre. Given that the mediation process varies greatly from one country to another, would there be merit in some degree of harmonization? Maybe you could also talk about language problems in cross-border. Diana. Yes.
I think the beauty of mediation has always been its diversity. And I would be very worried about trying to cajole everybody into using the same style of mediation. I mean, most of us are familiar with sort of the 5 phases of mediation, and those phases probably give us enough to hang on to. But after that, it comes down to a matter of individual mediator style. And as for the cross-border sort of cultural differences, that again depends, I think, very much on the mediator, but also if it's a commercial case that can take it, I would say there is every reason to argue in favour of co-mediation, where you have a couple of mediators, one perhaps from either language or cultural background or whatever's appropriate. And, you know, 2 heads are better than one for spinning ideas off one another and for helping the parties get through. But my initial reaction to some sort of, you know, we don't have one style of mediation in the UK, so why try to make one style across a wider area? But we do all have principles. There's a code of conduct, the European Code of Conduct, that I think none of us have any great difficulty with. So, you know, why do we need to sort of dragoon it anymore? I don't think so. It doesn't lend itself to that as a process.
Chris.
Yeah, I just, well, for the sake of controversy or not, actually, I genuinely believe this. But anyway, I'm going to disagree with Dan. Just to a certain extent. I mean, I totally agree with the benefits of flexibility of mediation. And in fact, I've been involved in a number of discussions around sort of trying to help the mediation community move away from the one-day model with all of the preliminary steps that we've got used to, because it's made people lazy and made the mediation process, I think, less effective. So I do agree about the flexibility, the benefits of flexibility. But that said, I also think that some element of cross-border harmonization will so significantly benefit the growth of the use of mediation in cross-border disputes that it's worth the price that you pay. And in reality, people will end up doing things largely the same way in any event. So it's difficult. There are pluses and minuses. So I think there is the benefit there. I see Diana waving, so I was going to make one more point. But Diana, what did you want?
Well, I just want to ask you, what would you harmonise? What would you harmonise?
Well, for example, you would perhaps normalise, and this is because I come from a private meeting tradition, the use of private meetings, so that the suggestion that you're going to use a private meeting wouldn't come out of the blue or be considered to be improper or baffling to one side or the other. So if it doesn't mean you're exclusively going to use private meetings or predominantly, but at least that their use is is understood and has become normal. I would just let me just mention one small thing. The way that the ICC mediation rules try to deal with this is to say that, and to enable parties to agree to mediation without worrying about what they're agreeing to, is to say that if you've agreed to mediate, you agree to stay in the process until a first meeting with the mediator, after which the mediator sets out in a note how the mediation is going to progress. So at that point, the parties know what sort of mediation they're going to get into, which the mediator sets out in the note, having discussed it with the parties. And if they don't like it, they're free to leave at that point, but at least they're committed up to that point. And that was the sort of compromise solution we came up when drafting the ICC mediation rules, to get people to commit to a process when they didn't really know what they were committing to.
Okay.
Yeah, thank you. We have another question, actually two questions. One which is quite long, and I do wonder if it would be better if you could actually read it rather than me reading it aloud. But it's relating to case where you have a mix of commercial and public law, such as a dispute between a private company and a public body, say in relation to utility regulation, subsidies, or procurement. I could see that government bodies may feel bound to stick to a narrow approach for fear of creating a precedent in an ultimately highly political area. On the other hand, it could be extremely effective. Oh, this is a difficult one. Who would like to try and answer? So it's the how effective mediation could be in a case where you have a mix of commercial and public law, like a dispute between private company and a public body.
I can try, Rita, but I'm not sure what the questioner is really getting at. One of the issues that's difficult, of course, in these sorts of cases is, for instance, many governments, our own included, have sort of signed up to be pro-mediation, that in where there is a dispute with a government department, they are meant to try mediation. The problem is they are a public body. They ought to be open and transparent. If they mediate a case, we, the public, don't know what has gone on. And sometimes that causes a tension between the need to be open and transparent as a public body and the requirements of mediation for it to be a confidential process. And it's more difficult than a problem than when you have two commercial parties. So that to me is the problematic that you face. Whether that's what the questioner has in mind, I don't know.
Somebody? No. Yes, there is a thanks. That's really helpful. The answer of the person who asked the question. There is somebody has got. Can somebody mute himself? Yes. There is somebody has a telephone. Right. Let's do this question. That's the last question, because otherwise we'll we'll go over the allotted time. And it's from Andrew again. Andrew, you are here. Do you want to ask the question yourself rather than me trying to interpret?
Yeah, I can do, because I can see Jonathan there, and he and I know one another very well. He's a bit puckish, actually. Typically, he's a slightly newer. Again, he's asked a question about arbitrators assuming power to make parties mediate, and he and I go back a long way promoting mediation. So, and I understand the temptation as an arbitrator to do that, but I think suggesting mediation when you're acting as an arbitrator is one thing, but assuming power to do that, I think is a very different thing. Unless it's actually written into the, obviously you can get them to agree, you can cajole them and nudge them into agreeing. And that's the skill perhaps of the arbitrator, say, look, come on guys, try and do that. Yeah, but make them, the word make is the one pricked up my ears, make. Yeah, unless that's in the arbitration agreement, I can't see how you can do it. I mean, it's nudging. It's like nudging, but anyway, that's. I mean, Jonathan might respond, or somebody else might respond, but I'd love the idea that within arbitration procedural rules, it'd be a standard rule that the arbitrator, in certain circumstances, can actually make the parties mediate. That'd be great, wouldn't it? But it doesn't exist, as far as I know, in any kind of procedural arbitration rules anywhere in the world.
What do our panelists think about it? Do you think it's possible, Chris?
Well, Jonathan's got his hand up, but I agree with Andrew. I'm sorry, I agree with Andrew that I don't think arbitrators can and I actually wouldn't want the provision in the rules enabling arbitrators to force parties to mediate either. Because, as I said earlier, in relation to court, I'm not sure mandating mediation is a good idea. But I think it's more about the right incentives. But Jonathan wants to answer directly, I think. If you're sorry, it's your call.
Yeah, it's all right. Jonathan?
Very brief comment. I'm not suggesting arbitrators mandate. I'm suggesting arbitrators go no further than an English High Court judge could go. There's a considerable area in arbitration where parties can agree. So if both agree that there should be a mediation window, that will happen. The issue therefore only arises where one party suggests mediation, the other party doesn't. For example, it's a claim of $1 million and the costs are projected, the way things are going, to become totally disproportionate to that claim amount. Can the arbitrators say, yes, we're persuaded by the party asking for a stay so that mediation can happen, that it's a sensible thing to do pursuant to our powers under Section 33 of the Arbitration Act to adopt sensible time and cost reducing procedures. So we'll give that opportunity. It's not compelling mediation. And then if the other party refuses mediation, and the costs do become disproportionate, then the arbitrators will have their discretion to mulct the declining party with an adverse costs order or some sort of split costs order. That's really all I'm suggesting, which would replicate largely the way an English High Court judge would deal with the matter. I think that's perfectly possible.
Jonathan, a 10-second reply. As arbitrator, I would have enough trouble with people accusing me of bias and challenging my jurisdiction. I don't really want to get involved with ordering them to mediate. That'll be another months of delay whilst they argue about that. The practical reality is, if you start going down that route, you're heading yourself into a world of trouble. I'm a practical commercial lawyer, okay, as arbitrator mediator. So
thank you very much. Maybe you could continue this offline.
Okay.
Right. Okay. Thank you so much to everybody for a really interesting and lively conversation. And I hope we will have another webinar on ADR organized together with the Chartered Institute of Arbitration on the 17th of June. So if you haven't had enough of ADR, you can join us there. And thank you everybody for being here, and thank you very much for our panelists for their expertise and their time.
Thank you.
Have a good afternoon, everybody.
Thank you.
Thanks.